been in practice for 43 years, 33 years in silk, and I specialise in trade union law and industrial relations, do a few other things as well, but that's mostly it. And I'm like John, I'm on the verge of retirement at the moment. But Jeremy put me into the House of Lords. Obviously, we were then hoping that there'd be a Labour government, and my role was to introduce comprehensive legislation covering the workplace, which I could go on about for hours and hours, but seems all a bit pie in the sky at the moment. So I'm a small group of people on the left in the House of Lords. We have to cooperate with the, well, I won't say more about it, but I mean, it's a pretty frustrating process. You can get some amendments through to legislation, but they're pretty peripheral. And when, of course, they succeed in the House of Lords, the Tory government knocks them back. So I'm dividing my time between just a few cases that I'm still got on the stocks as a barrister, and a bit of stuff in the House of Lords, and writing. And the writing stuff I do is all about industrial relations and trade unions and so on.
Many thanks. That was probably the least necessary introduction of the day, but so I'll just pass straight on to John now, who's going to talk to us about kind of the importance of a unionised legal sector, and maybe some of the obstacles that we might have to overcome to get there. Thank you, John.
Oh, well, thank you very much, Chair, and thank you all for inviting me to speak this afternoon. I feel very honoured to have been asked. Lois gave me terms of reference without any limit at all, so I thought I could talk about anything I want, really. So what I thought might be helpful would be a sort of brief history of labour law and trade unions and the struggles over time to bring us up to the present day. I'll do that, relatively quickly, and then say something about trade unions in the legal sector. I should say at the outset that trade unions in the legal sector, although they're not a new thing, they've not really been terribly effective in the past. But the need for it is obvious, both from what everybody's already said this afternoon, but also because it's apparent to everybody the degree of misogyny, racism, discrimination, and in particular exploitation through low wages and insecurity of employment that exists in the legal sector. And the idea that lawyers are a profession which stands apart from ordinary industrial relations is, of course, absolute rubbish. So the need is obvious, and the benefits of trade unionism are absolutely clear: solidarity, the exercise of collective strength, and all those peripheral things as well, like having a union to represent you if you have a personal injury. And of course, nobody imagines for a moment that the legal workplaces, whether you're working in an office or from home, are free from dangers to health and well-being of workers. So those things are very important. So let me kick off with just a few words about labour history, because a lot of trade unionists, and no doubt a lot of lawyers who are trade unionists are not perhaps as familiar as they could be with the struggle for trade unionism over the centuries. History of trade unionism in this country really is probably as long as anywhere else in the world, and it goes back about 300 years. You're talking in the middle of the 18th century, when people came together in an organized fashion, forming actual organizations rather than banding together for immediate demands for whatever it happened to be, against dismissal or for higher wages or whatever. But legislation against combinations of workers is a lot older than that. The first if we talk about modern history, that's to say post-medieval history, the first ordinance is in the middle of the 13th century, when a royal ordinance barred brick workers in London from demanding that anybody who came from outside London as a bricklayer would be paid London rates. And I always think that's a very important indicator of where the law stands in relation to trade unions. So this was legislation preventing people maintaining the rate for the job, which had been established across London in the brick building boom that there was in London in the 13th century, for having their terms and conditions undercut. Of course, that wasn't the first ordinance against combination, because we know that 3,000 years BC, we know this from hieroglyphs in one of the pyramids, that there was a stoppage of work by slaves over better conditions. What the hieroglyphs don't tell us is whether they succeeded in their industrial struggle or whether they were all buried alive or whatever happened to them. So legislation has been used against workers coming together for a very, very long time. And in the 16th century, there were two particular ordinances, Statute of Labourers. I forget the name of the other one, but these required that wage rates in agriculture, which of course was the predominant occupation of the vast majority of the population at the time, would be determined by magistrates. And the reason for that was that after the Black Death and the death of a third of the population, there was a shortage of labour, and consequently Labour had a much stronger bargaining position than it had before, and could therefore demand higher wages. Well, that was put a stop to by legislation which set the wages by agents of the state, namely the magistrates. So when you come to the 18th century, with the rise of trade unions in a fairly sort of modest and piecemeal fashion, enterprise level unions, of course, which is how trade unionism always starts, then both the common law and legislation were wheeled into action against unions. In legislation, of course, after the French Revolution, which scared the elite to death, there were two particular acts, the Anti-Combination Acts of 1799 and 1800, which forbade combinations of workers. And the common law was also used against unions in diverse ways. Obviously, the crime of conspiracy was a particular one. I'll say a word about that in a moment. But we see all sorts of other bits of law used against unions. In particular, of course, the legislation used against the Tolpuddle martyrs in 1834, probably the most famous labour law case in history. And that what they got them for was taking an oath, and the oath that they took was simply an agreement that they would not work for less than what had been established as the going rate for agricultural labourers in Dorset. And for that, they were transported. But of course, there was a massive campaign, a backlash for that, which led to Chartism. And well, we can't go wider in our quick tour of history this afternoon, but there was a backlash against it. But it just shows the way that the law has been utilised, bits of common law that have never been thought to be relevant to industrial relations, statutes passed, all with a simple aim of reducing the collective power of workers to bargain for better wages and better conditions, or simply to maintain wages and conditions which had already been established. I said I was going to say something about conspiracy, and conspiracy is very important, both criminal conspiracy, which was put out of which no longer became really relevant after 1875, Conspiracy and Protection of Property Act of 1875, although indeed it was used against the Shrewsbury pickets in 1972. You know, Ricky Tomlinson and his colleagues, who were arrested 6 months after the strike had concluded with an amicable settlement with the employers. These guys were arrested allegedly for intimidation and incitement to violence whilst picketing on construction sites, which happened to be, in that case, it was a national strike, but these were in Shrewsbury. But criminal conspiracy really is not significant now. But the relevance I wanted to draw to your attention was this, that it was used also on the basis that combinations of workers and the very concept of collective bargaining, that's to say workers collectively through their trade union, entering collective agreements with employers with minimum terms and conditions, was regarded as a restraint of trade. And because it was a restraint of trade, any agreement to operate in that way or to support a collective bargaining or collective agreements was naturally a conspiracy. And that was rectified in Trade Union Act of 1871 by saying that trade unions by definition were in restraint of trade, but that the restraint of trade would not render a trade union unlawful. And that has resonances today, because those of you familiar with EU labour law will know the case of the litigation which is in the CJEU, three particular cases where it was held that collective bargaining by employees was not in breach of competition law, but collective bargaining and collective agreements formed by associations of the self-employed were in breach of competition law, because a self-employed person is ranked as an undertaking, and Article 101 of the EU Treaty, which is the regulation of competition law, which is reproduced in our Competition Act, forbids agreements between undertakings which set the terms for the supply of goods or services. So this was a major problem. The CJEU, in fact, a few years ago, 2016, 2015, in a case called Kunsten Media in the Netherlands, found a sort of halfway house, but it's not satisfactory. And this is something which is being negotiated by the ETUC, with the European Commission, as we speak, in the hope that a solution can be found. But I've got no doubt that since Brexit, there will be employers who will seek again to use competition law to say that the protection against restraint of trade for trade unions in some way doesn't extend to protection against competition law. The ingenuity of employers and their lawyers through the centuries is really quite amazing. Anyway, I've gone off track a bit. I just mentioned the 19th century and the development of collective bargaining. Now, collective bargaining by trade unions was originally enterprise-based, but as the century wore on, what we find is that there was collective bargaining on a local basis for particular trades. So a famous agreement entered in the Nottinghamshire area for lace making in the 1860s. Some regard as the sort of beginning of sectoral collective bargaining. And what's important about that is, and I'm going to talk about sectoral collective bargaining at the end of my piece this afternoon, but what's important about that is that that agreement was led not by the workers, but by the employers. It was the employers in the lace-making industry in Nottinghamshire who demanded that their competitors should all be bound of course, were in perpetual fear of being undercut by other workers in their trade, in their locality, working for less money. So collective bargaining, and in particular on a sectoral level, developed through the 19th century and gained some support in Parliament. And we can see that support with the Fair Wages Resolution of, I forget the year now, 1894, 1896. I can't remember. One of those years, anyway, just before the end of the 19th century, Fair Wages Resolution of the House of Commons, which essentially said that public contracts let by government would only permit workers to be employed on the going rate in that locality for that trade, and that meant the collectively agreed rate. The Fair Wages Resolution was developed further in the 20th century and became more specific. And we're now talking about public procurement, and there are directives from the EU which have been introduced into UK law which permit public procurement contracts to specify today that workers are not employed in breach of International Labour Organization conventions and other provisions upholding collective agreements and so on. And the consequence, not the consequence, but what this recognized is that towards the end of the 19th century, even government and good big employers were supporting the idea of collective bargaining because it avoided major industrial disputes, and there were some huge ones at the end of the 19th century, dock strike of 1889, and other big strikes, and the period from 1910 to 1913, some historians call the Great Unrest, massive strikes in all sorts of industries, insisting on minimum terms and conditions for that particular industry. This was being recognized by employers and by governments who didn't want industrial rest and who were prepared to uphold minimum terms and conditions in order to prevent undercutting. And in 1909, for example, Winston Churchill introduced the Trade Boards Act, which subsequently became, trade boards became the wages councils. Wages councils ultimately, by the 1950s, extended to 4 million workers in Britain, which was a substantial part of the workforce, which was a form of statutory collective bargaining, the consequences of which each year the collective agreement was binding as a matter not merely of contractual law, but of criminal law as well, on all the workers and employers in the industry. Wages councils, of course, trashed and abolished by Thatcher in the 1990s, last agricultural wages, the last wages board, the Agricultural Wages Board for England and Wales, abolished in October 2013. So, and then of course we got to the First World War. There was all sorts of regulations against strikes and so on. But in order to have productive war industries, collective bargaining was a major instrument of industrial production. And after the Second World War, in consequence of the Whitley Committee, J.H. Whitley, former Speaker of the House of Commons, who set up a committee under the Ministry of Reconstruction to promote collective bargaining across the entire country, voluntary collective bargaining in parallel with the wages councils and so on. And it took off slowly, but it did take off. It was set back in the 1920s because of major depressions at the beginning of the 1920s, which led ultimately to the great slump of 1929. But in the 1930s, there was a realization that collective bargaining was the way out of slumps and depressions. And collective bargaining became more and more extended throughout the 1930s, and it was a major tool during the Second World War, obviously promoted by the Secretary of State for Labour, Ernie Bevin, former General Secretary of the Transport and General Workers Union, but accepted by right-wingers like Winston Churchill and so on. So collective bargaining well established in the Second World War and took off after it. Of course, there were, as we know, statutory inhibitions on the right to strike and take industrial action. We haven't got time to go into the intricacies of that. But that post-war consensus of collective bargaining, particularly at sectoral level, allowing workers through their trade unions to determine the minimum terms and conditions for the industry nationally, was an essential element really for the best part of 50 years. And if you go back to, take it from 1939, let's say 40 years, until, of course, that doomsday moment in 1979, when Margaret Thatcher was elected and neoliberalism displaced Keynesianism as the dominant industrial economic ideology. And her view was, like Hayek and all those horrible bastards that were the thinkers for neoliberalism, that there should be a return to a free market, which means in labour that workers should be required to work at the cheapest possible price consistent with their survival. So a free market means a free market in everything, including labour as a commodity. And that's as they regard it. So since then, we've had the breakup of collective bargaining, the ending of the wages councils, the ending of the fair wages resolutions, and of course, as you all know, major restrictions on the exercise of the right to strike in order to deprive unions of really significant power to exert a countervailing pressure on employers, which of course would be, if you were a philosopher, is an essential element of a free market. Obviously, if in a free market, everybody should be allowed to exercise whatever power they can to get the best outcome for them. But neoliberalism, of course, has persisted since 1979. We saw no significant movement away from it in the 13 years of Labour government, no restriction really on the impediments to proper progressive labour law. They introduced a compulsory recognition, which might actually be of use in the legal sector in the future, but in terms of the 33 million workers in this country, it is insignificant. The consequence can be measured in the statistics. From 1945 through to 1979, the level of collective bargaining coverage, that's to say the percentage of British workers that had one or more terms and conditions regulated by a collective agreement, was 82%, around, well, over 80%. So 4 out of every 5 British workers had terms and conditions regulated by a collective agreement. That percentage now is less than 25%. And the decline from 79 through to 2020 has been absolutely consistent. There was 1 year in which it didn't fall, didn't rise, but it didn't fall. And that was the year 2000, after the recognition machinery came in. But if you look at the slope of the curve after the year 2000, it's exactly the same angle of declination as it was from 79 through to 1999, when the legislation was introduced. So that's the trajectory we are on, the destruction of collective bargaining. Of course, this country is not unique. We see the same thing in America, who were in advance of us in introducing neoliberalism. And because of the legal context, collective bargaining was smashed up a lot earlier in the United States. In fact, it never reached the same levels as in Britain. But in Europe too, the level of collective bargaining has been falling. And it's only now that the European Commission is suddenly realizing that actually collective bargaining might be a way forward. And it's very interesting that if you look at the organizations like the IMF or the OECD, not revolutionary, not even progressive in any way at all. The OECD does a state of the labor market, I forget what it's called now, every year, big thick book, 600 pages odd. And for the last 4 years, it's had an entire chapter devoted to collective bargaining. They are advocating a return to collective bargaining. Because the big employers bear the cost of research and development. They're the employers that put in the investment for efficiency and so on. But the little employers can compete with them simply by undercutting labor costs and making no investment at all. That's one big factor. But the other factor, and the really big one, which is relevant to Rishi Sunak's announcement last Wednesday, is that if you let wages fall, you drain demand from the economy. If you drain demand from the economy, employers have got no one to sell their goods and services to. It's absolutely essential to increase the capacity of working people to have wages and to spend them. The economy absolutely depends on it. And it doesn't matter if you're the manufacturer of Lamborghini cars, which will never be sold to somebody who's working 10 hours a week stacking shelves in Tesco's. Their money that they spend on whatever they spend it on, probably food and rent, ultimately is spent by those who accumulate wealth, who can buy Lamborghini cars. So as wages fall, the demand for everything falls. And this is the stupidity of Sunak imposing a wage freeze on the public sector, especially on the outrageous basis that it's unfair to other workers that they should be so deprived. I mean, let me not go there, otherwise you'll have half an hour rant about those bastards. Anyway, so that I hope that's in a thumbnail that gives you an idea, and that's why trade unions and the collective voice of labour has been suppressed over years and years of this false belief in a free market, absolute total ignorance of the basis of economy, which depends on a large number of working people spending as much money as possible. And of course, one of the things about working class people is that of necessity, they spend their income. They don't sort it away in the Cayman Islands. They actually spend the stuff. And there's a famous story about Henry Ford in 1929, who raised the wages of Ford workers in order that they could buy Ford cars. Of course, he had the motive that would be more Ford cars as an advert. But the principal economic factor was that by raising wages, he actually made more profit because he could manufacture more cars. And this sort of simplistic understanding of the economy is all too pervasive, and it's our job as trade unionists and members of the labour movement to allow people to understand the reality of economics and the crucial nature of workers having their voice. So let me just say a word about the modern situation for workers. Of course, I support lawyers joining trade unions. I was never active in a trade union. I'm an honorary member of the National Union of Mine Workers and have been since the work that I did for them during the Great Strike of 84 to 5. But I'm a member of Unite now, the community branch, because there's not much I can do in my workplace about trade unionism. But for those who are at the bottom of the legal pile, if you forgive me putting it in that way, I think it's absolutely crucial. I won't say any, because I am standing counsel to 8 different unions, I won't say anything about the merits of the union to which you guys join as opposed to the merits of other unions. You've obviously made your assessment of which union is the most likely to be active in the legal sector, and who am I to dispute that with you. But it is of course vital that workers are represented collectively, because they have no other way of exerting a countervailing power to the overwhelming power that employers have over them. There is no other way. There is no possible alternative. And I hear people arguing, particularly in the Labour Party, saying what the crucial thing is we have to raise the minimum wage. And I say, no, that isn't the crucial thing. It's important, of course. Raising the minimum wage does get money into the pockets of some people that need it. But you've got to remember certain things about the minimum wage. And Chair, if you forgive me just digressing a moment to speak about that, but hopefully it's of some relevance to you. The minimum wage, national minimum wage, has got certain features. One is that it's not a wage. If you talk about the minimum wage in Europe, in France or in Germany or in Spain, they mean a minimum salary per month. That's what they mean by minimum wage. In Britain, it's only an hourly rate. So if you only do 10 hours in Tesco's, and the minimum wage is whatever it is, £8.67 or whatever, you're only going to get £86.70 a week, and nobody can live on that. It cannot be done. So we're not talking about a minimum wage, but perhaps more importantly and more relevantly this afternoon, workers have no say in setting the national minimum wage. There is no industrial democracy in a minimum wage. It's set by good-natured people in the low-pay unit who do an assessment of what the average wage rates are and apply algorithms to it and so on, but it's not set democratically, and it's not set a reflection of any collective voice on the part of workers. And that's why I think that we should not focus on the national minimum wage. What we need is the restoration of collective bargaining. And that's what you guys are going to do through your union in the legal sector. And Chair, I'll conclude by saying this. I and my colleague, Professor Keith Ewing, have been advocating the return to sectoral collective bargaining since we wrote a book about it called A Manifesto for Collective Bargaining in 2013. And we managed to persuade the former Labour leadership that this was a crucial element in the post-election legislation. It was in the 2017 election manifesto and in the 2019 election manifesto. And by last December, when the election was, we had rolled out a blueprint for what the legislation would look like to restore sectoral collective bargaining across British industry, sector by sector. It wouldn't been all done in one go, but we could have made a start on it. But the important thing was that the collective bargaining should be sector by sector, and that minimum terms and conditions should be set for the sector, below which nobody should fall. And on that basis, you can have collective bargaining at enterprise level, which would improve on and would not be permitted to derogate from whatever the sectoral standards were. And of course, this is a big burden for trade unions, because if you're going to negotiate on a sectoral level, you've got to be able to demonstrate that you've got some sufficient degree of representativity, and you've got to have a mechanism, a democratic mechanism, for allowing the workers to set the demands and for giving a voice to workers in deciding whether they're going to accept or not whatever the counteroffer is from the employers. So in some industries, legal sector might be one of them, this would be quite difficult to do. But it's a goal that I think every person committed to trade unionism should have uppermost in their minds. Of course, it would help if we could have legislation of the kind that we designed to facilitate this. But even in its absence, it would be possible to achieve it. And the legal sector's crying out for it. It's such an obvious sector for minimum terms and conditions. And finally, I'd just say this about it. When we set out our blueprint for a return to sectoral collective bargaining, we didn't just restrict it to a minimum wage rate or maximum number of hours. We said that it ought to extend. I think we had 54 different headings. Everything was covered. Apprenticeships, in your case, trainees or pupilages or whatever, the number of them, how they ought to be paid, who is to fund that, the training that goes with it, who is to pay for the education of the apprentices. Is it the employers that get the benefit, or is it the state, or is it a bit of both? How is that to be done? What numbers of apprentices should be taken on by enterprises and so on? And in terms of wages, we were talking about minimum wages, wages for to reflect degrees of qualification, experience, different wages for night work, for antisocial hours, for travel allowances, everything that you can imagine. Promotion, trees, the progress through levels of promotion, how that's decided, what workers to have a say in determining promotion and so forth, eradication of inequality in the ethnic pay gap, the gender pay gap, in chances of promotion, in training and so forth and so on. Chair, you probably listened to my voice long enough now. I'm sorry if I haven't covered the things that Lewis really wanted me to cover, but I hope that that'll provoke a few questions anyway.
Well, thank you very much, John, for that incredibly insightful kind of run through of the history up to the situation we're facing today. I think what it really illustrates kind of is both the weight of capitalist power that workers have and always will face, and also as a result, as you were saying at the end, how disciplined we have to be and how ambitious we have to be as a trade union in order to correct that. I'm conscious of taking up too much of your time, but do you have time for a couple of questions?
Yeah, sure.
Thank you very much. Does anybody have any questions they want to either put a star in the chat or write them in the chat and I can ask them? If not, then I definitely do, but... Okay, Frank, do you want to
go? Yeah, thanks very much, John. That's incredibly useful to hear that history. I suppose what I would ask you is, how viable do you think it is for workers in the legal sector to go on strike, and what obstacles do you think lie in the way of legal sector workers taking strike action?
Well, I mean, it is viable. It has been done only on an enterprise, at an enterprise level. sectoral strikes are possible, but of course, in order to get the protection of the Section 244 of the Trade Union Labour Relations Consolidation Act, you've got to be in furtherance of a trade dispute, in contemplation or furtherance of a trade dispute with your own employer. So everybody would have, in the legal sector, everybody would have to make demands of their own employer. Now, this can be done at sectoral level. We saw it in the pensions dispute, must be 5, 6, 7 years ago with Unison. I think they called a strike of 750,000 workers employed by something like 30,000 different employers. I mean, but a formidable task of logistics and organization to do that. Legal sector is not so big, but the problem with the legal sector is the fear of victimization, isn't it? Because you're all in small workplaces, and it's employer says, well, there'll be no victimization, but if you go on strike, your promotion or your next pay rise might take a little bit longer to achieve. And people, particularly in times of contraction of the industry, and there have been contractions in the legal sector, are very, very nervous about it. So industrial action, I think, is clearly possible, and the legal loopholes can be steered around with skill and imagination, preparation and investment and time and resources. But I would have thought the sort of naming and shaming and sectoral demands supported by the great and the good might be more productive to begin with while you're flexing your muscles. But you guys know a lot more about the legal sector than I do. I'm so old now that it's sort of it's a river flowing underneath my feet, and I'm standing on a bridge.
But that's really helpful. I really appreciate that. Really helpful answer.
Should we have one more question if anybody has one? I think maybe your history was so comprehensive, John, that it answered the questions already.
Particularly, put everybody to sleep.
Well, I don't think so. Big up the Egyptians, by the way. That's mad. I think, unless anybody has one else, we'll let you go.
I have one quick one, just to clarify the point. You mentioned some stats previously. I'm trying to find my tweet about that. I think it was 1945 to 1989, and then the percentage of collective representation after the decline. I just wanted to double check what those stats were.
They're statistics that were originally collected by the Workplace Employment Relations Survey, which is a annual survey. There are two surveys: Labour Force Survey and the Workplace Employment Relations Survey. And they used to always ask a question or questions which gave rise to their analysis of the statistics for collective bargaining coverage. Keith Ewing and I wrote a book in 2016 called A Manifesto for Labour Law, published by the Institute of Employment Rights. If you go on their website, you can buy that. It's, of course, a brilliant read. But we've got all those statistics are in there, and I footnoted all the references to the material that gave rise to those statistics. They are well published. I mean, the government now publishes it's in one of the ONS Office for National Statistics series. They publish the level of collective bargaining coverage, and at the moment the last figure was 2018, and it's put at 26%. But I actually don't believe that, and the reason is that I'm not convinced that they exclude, as they should, those public sectors where pay is regulated by a pay review body, because that's not collective bargaining. But of course, it's the whole of the teaching profession, the whole of the prison and police services, and various other sectors. So you're talking about another 2 million people included there that should not be included. And as I say, even if that was true, such is the decline in collective bargaining coverage that we must be below 25% now. Now, those statistics are available. You probably Google them, but be careful if you do. Don't go to Eurofound or to the ILO, because they take the government official statistics. So there's always a time lag behind. But the ONS statistics were published, I don't know, within the last year or so.
Just one last question from Adrian, if that's okay. Adrian? Oh.
Sorry, I was just struggling to unmute myself. John, thanks for that. You mentioned the European case law differentiating between employees and the self-employed. And you're obviously a barrister yourself, so I'm sure you'll have a lot of thoughts about this. I mean, how do you think barristers or barristers' chambers could organise? What would that look like, and what do you think they could achieve?
I don't know, to be honest. I mean, barristers are plainly self-employed, but barristers' chambers are a collective enterprise, and there's obviously a certain common. There are certain common issues shared by those at the very bottom, pupils and the very junior tenants. I mean, the pupils are in such a precarious position that I wouldn't have thought that it would be terribly wise for them to combine, but junior tenants could exercise some leverage. But on the other hand, it's very difficult, isn't it? It's not as if those that at the top have a control over the rates of remuneration of those at the bottom. So there's not much you could do on that. It would be more about the common conditions, about, for example, how is rent to be calculated. I mean, in our chambers, it's just simply done on a flat percentage of receipts, which has tremendous advantages to it, because it's very egalitarian. If you don't earn a lot, you don't pay a lot at the bottom, whereas those at the top are paying a great deal more in cash terms, as they rightly should. And it means that, for example, women going on maternity leave, as their income falls, as their receipts diminish over a year or something, pay less and less, which is very attractive. I mean, there's opportunity for some sort of extra payment, but I think so. Issues like that, or the allocation of rooms, and whether the junior tenants are getting enough input from the clerks and that sort of thing, are common issues which could be dealt with on a collective basis, I'd have thought.
Thanks.
Yeah, thank you, John. That last answer is actually really interesting, because I think how to meaningfully organise in chambers is something that we've been thinking about as a union and trying to grapple with for quite some time. As you say, there are clear power differential issues, but it's quite hard to see always a way of connecting different workers in that situation. I think we'll say thank you very much from everyone here for coming. It's really, really been a pleasure to have you speak, and we're very grateful for that. So thank you. And I know you have these connections with various unions, but I'm sure LSWU would be happy to have you as a member at any point if you do decide to join.
Well, thank you very much. Thanks for having me. Thanks for listening. I'll see you. Bye.
Cheers. Bye, John. Thank you.
Thanks very much.